I would now like to invite Professor Aurelio Gurrea Martinez, Associate Professor, Singapore Management University, for delivering the valedictory address.
Okay, good afternoon, everyone. So, first of all, I would like to thank the organizers for the honor to invite me to deliver this address. So, it's an immense honor to be here for several reasons. First, because I've been a great fan of what India has done in the past few years. I've been closely following all the reforms and evolution of the insolvency and bankruptcy code. And particularly, I've also been very actively following the amazing work that the Insolvency and Bankruptcy Board of India has been doing. So that's why it's an immense honor to be invited to deliver this address. Secondly, I can see many faces here, particularly the Honorable Justice Kanan Ramesh from the Singapore Supreme Court, Mr. Suman Batra from Insolvency Law Academy, so many colleagues and friends, practitioners, judges, regulators, scholars from India and around the world here. I'm also a great fan of the amazing work that all of them do, so that's why I don't think I really have anything to add to what they already know and what they already do, so that's why I'm just going to share a few thoughts about some of the most exciting, I would say, research projects that I've been conducting in the past few years. And particularly, I would like to thank the Insolvency and Bankruptcy Board of India and the Indian Institute of Management, Bangalore, for the kind invitation. When they sent me the email a few months ago already, I thought that it was a mistake because I saw in the program all of these distinguished speakers, colleagues, friends from around the world, and I said, well, again, I don't think I have anything interesting to tell them, but at least as an insolvency enthusiastic, as I know that many of you are, probably all of you, because it's Sunday morning, and the fact that you are all here after 3 intensive days of this amazing conference, so you need to be an insolvency enthusiastic in order to be here. So that's why I said, well, at least maybe one insolvency enthusiastic can share with others what I've been doing in the past few years with the purpose of getting feedback and hopefully to try to keep working together on improving the way we think about insolvency law. So the topic of my presentation is actually the title of a book that is going to be published in the next few months. I still have some time for minor changes, so that's why I would love to hear your views. So just in case that I need to change something, I still have time. It's going to be published with Cambridge University Press, and it is based on a research that I've been doing in the past 3-4 years, where I've been analyzing insolvency systems in about 80 jurisdictions around the world. I've developed a new index to measure the attractiveness of insolvency laws from the perspective of debtors, from the perspective of secured creditors, and for the perspective of unsecured creditors. So I developed about 20 variables that can help me assess how attractive an insolvency law is for debtors, how attractive an insolvency law is for secured creditors, and how attractive it is for unsecured creditors. So the index will probably be published by the end of this year, but this index has been very helpful for my own work and understanding of insolvency laws around the world, because I've been able to find many similarities, I've been able to find many divergences, I've been able to find many common weaknesses, common strengths of insolvency laws around the world. And I found something incredibly surprising, which is that if we look at the insolvency law in Malaysia, for example, it's not very different from the insolvency law that Singapore used to have prior to the 2017-2018 reform. If we look at, for example, insolvency law in Ghana or in Nigeria, they both amended the law a couple of years ago in 2020, it's not very different from the UK insolvency system. So if we look at many other jurisdictions around the world, we can see that actually the law in many emerging economies replicate the best international practices that are often mentioned by some international organizations, and they often replicate practices and provisions existing in other jurisdictions. So that's why the purpose of this book is to challenge what I think is a mistake, which is just to copy and paste some of these good practices and some of these laws from other jurisdictions. So that's why what India has done is incredibly impressive. I think India is a unique example in many ways, but even when it comes to the design of insolvency law, I don't think that there are other countries with a similar framework. So I'm not saying that this is necessarily good or bad. Then we might have the chance to assess more critically maybe some of the weaknesses, some of the strengths of the Indian insolvency framework, but at least it's something unique. It's not like, oh, we are a common law country, let's just look at Singapore, let's look at the UK, and just cut and paste what they have, which is unfortunately what many countries, particularly Commonwealth jurisdictions, have done. Or also in Latin America, you can see sometimes some of the similarities with some European regimes, particularly Spain, France, Germany, have inspired some insolvency reforms in Latin America. Also, Morocco has very much been inspired by France. So you can tell sometimes based on legal origins, based on geographical location, based on the influence of certain international organizations, all of these similarities. So that's why the title is that we need to think about insolvency law differently in emerging economies. And I'm going to explain or try to explain why we need to think differently, why we need to reinvent insolvency law in emerging economies. So, assuming that the slides work. So, can someone help me with these slides? So the basic assumption to start with is that sometimes I think that in the academic and policy debate, we forget about the importance of insolvency law in emerging economies, when the truth is that emerging economies, broadly understood, so emerging markets and developing economies, represent 85% of the world's population, because we're thinking about India, we're thinking about China, but we're thinking also about Russia, Brazil. I would say most countries around the world are emerging economies. Only 20-something countries are classified according to the IMF as advanced economies. So most countries around the world are emerging economies. And sometimes the literature in insolvency law seems to forget that fact. And they focus on insolvency law in Europe, in the UK, in the US, a few other jurisdictions. There are some also a vast of literature on Chinese insolvency law, India insolvency law, some papers on Brazil insolvency law, but still more needs to be done. Because also in terms of GDP, emerging economies represent about 60% of the world's GDP. And I mean, I think I am in a place where I don't need to mention the advantages of having an efficient and also an effective insolvency regime. But sometimes I think the benefits of having an insolvency regime is underestimated by our policymakers, by the regulators. So fortunately for India, it's not the case of the Insolvency and Bankruptcy Board of India. But unfortunately, in many countries around the world, politicians, regulators don't seem to be aware of the importance of insolvency law. I always tell my students that insolvency law is more important for solvent companies than for insolvent firms. And why is that? Because I always tell them that there are three best ways to avoid a situation of insolvency. The first one is don't start a business. If you don't start a business, don't worry about all of these problems that we have been discussing during the past 3 days. So you are not going to become insolvent, no filing for bankruptcy, nothing's going to happen. Second best advice to avoid the situation of insolvency, don't borrow. If you don't borrow, by definition, you don't have creditors. You cannot become insolvent. And third is don't take risks. So if you don't take risks, maybe you're not going to avoid the risk of insolvency necessarily, but you're going to significantly reduce. But of course, if you follow this recipe, you are going to be destroying entrepreneurship, you're going to be destroying access to finance, you're going to be destroying innovation, you're going to be destroying the opportunity to have companies obtaining the financing needed to pursue value-creating investment projects that can ultimately create jobs, create wealth, and create growth. So that's why, regardless of whether the insolvency system is basically accepting applications or not for insolvency, that doesn't mean that the insolvency law is not relevant for the real economy. The moment that we enact an insolvency legislation, debtors are going to react. Because if you tell debtors, hey, if you become insolvent, you might end up in jail, as it used to happen in the Middle East until very recently in some countries. If you tell creditors you are not going to get anything in insolvency, you're going to be subordinated, then creditors are automatically going to be reluctant to extend credit, or they will increase the cost of debt. So that's why sometimes we think about insolvency law as a mechanism to help insolvent but viable firms, or sometimes we think about insolvency law as a way to reallocate the assets of non-viable firms when they become insolvent. And it's true, but that is the ex post vision of insolvency law once we already have the problem. But insolvency law is far more than that. It's about the ex-ante effect of insolvency, and even when we think about insolvency law ex post, insolvency law also plays a major role in reallocating assets efficiently. By definition, resources are limited. So that's why what insolvency law needs to do is just to reallocate the debtor's assets efficiently. If those assets are worth more alive than dead, or if the company is worth more alive than dead, and we have been listening to this fantastic panel on valuation previously, then the most efficient allocation of the asset is to keep that firm alive. And that's why what insolvency law should do is to provide us with the right tools to facilitate that rescue. But if the value of the firm is worth more in other alternative uses, as it typically happens with non-viable firms, the insolvency law should just help us liquidate that firm quickly. But also, by maximizing the returns to creditors, many of those creditors are going to be banks. If these banks don't maximize their recoveries, that is not only a problem for the bank, no. That's a problem for the whole economy, for every single citizen here, because that might end up increasing the levels of non-performing loans in the banking sector, and that even jeopardize the stability of the financial system. And that's why sometimes they can even lead to a sovereign debt crisis, because sometimes, as we saw in the Euro crisis with Greece, or now with the situation of Sri Lanka, let's see how it goes, but sometimes a problem in the real economy will be translated into a wave of corporate insolvencies, and if we don't stop that, that may be translated into a banking crisis, and that may be translated into a sovereign debt crisis. So that's why insolvency law is incredibly important. And still, it seems that some politicians and some regulators in some emerging economies don't seem to care about the importance of insolvency law. Because what I'm saying, in other words, is that insolvency law can be an essential pillar to reduce poverty and promote growth. And that's what we want, particularly for emerging economies. But when we think about insolvency law in emerging economies, we need to think about the particular features of the emerging economies. And of course, there are many divergences around the world. But some of the common features are those that I am including here. So most emerging economies have a huge potential for growth. Most companies are micro and small enterprises. And even among micro and small enterprises, for example, India is the case of one of them. The majority of these micro and small enterprises are actually sole traders. Some statistics that have been analyzing show that about 90% of the micro and small enterprises in India are sole traders. This is incredibly important when thinking about a framework for micro and small enterprises, because the framework cannot focus on small companies, because most micro and small enterprises are not companies, are sole traders, so we need to think differently about the framework. Most of our large companies have controlling shareholders, typically a family, typically the government, but most of them are SOEs or family-owned firms. And also problems of financial exclusion, particularly in rural communities. In many emerging economies, maybe this is not the case of India. That's why I said that there are many divergences. Because China or India have relatively developed capital markets. But if we think about Cambodia or Myanmar or Dominican Republic, then they don't have developed capital market. That's another common feature. When we think about the institutional environment, So most emerging economies have weak institutions. And weak institutions broadly understood. Think about the judicial system. The judicial system might not be very efficient. The judicial system sometimes is efficient and with very competent judges, with independent judges, but these judges don't have the resources to handle the cases quickly and effectively. In other countries, it's even worse. They may have even problems of corruption, lack of independence of the judges, lack of competent judges to deal with complex insolvency and commercial disputes. So all of these weaknesses that probably sounds familiar to many of you here are common weaknesses in most emerging economies. There are a few exceptions. For example, Uruguay is a country that in the ranking of the rule of law globally is ranked ahead of the United States. Uruguay. And also Chile is relatively well positioned as well in the ranking of the rule of law. And then, of course, there are many exceptions also when it comes to corruption. We will see here I have some data that I'm going to show you about the level of corruption around the world and also the commitment to the rule of law. But in general, another problem existing in many emerging economies, again, not in all economies because there are many differences around the world, is that this lack of commitment to the rule of law, which leads to uncertainty, lack of predictability, and lack of predictability is bad for business, is bad to promote access to finance, and therefore it's bad to promote economic growth. So here you have the rule of law index with data from 2000 to 2022. So just a few months ago was published. So we can see that with a few exceptions, mainly Scandinavian countries, Singapore, New Zealand, Canada, the US, Uruguay, Chile in Latin America, the green part, but with a few exceptions, most countries around the world face some problems when it comes to the rule of law. And when it comes to corruption, I am afraid to say that the red part are countries with problems of corruption. So corruption is everywhere. So again, the only countries that escape from this index are mainly Scandinavian countries, so the yellow countries. Scandinavian countries, Singapore, New Zealand, somehow Canada, even in the US, is not that yellow as some of you might expect. But with the exception of Singapore, New Zealand, Australia, Scandinavian countries, so some countries have more or less problems of corruption, like Venezuela, for example, which is the intensive red color there. So it's one of the countries with more problems of corruption, but it's generally a problem existing in most emerging economies. So then we might not expect to adopt some practices that might require the involvement of courts, the involvement of public institutions, in the design of insolvency law in some of these countries that are far from having the good institutional environment that might exist in Singapore, that might exist in the UK, that might exist in some countries in Europe. So if we look at now what happens in most jurisdictions around the world when it comes to insolvency law, again, there are many exceptions, and I'm going to mention some of them. But we look at the insolvency laws, and there are some similarities. So generally, insolvency laws are unattractive to debtors in many emerging economies. So the problem is not only maybe in India, or it's not only in Cambodia, it's also in Bolivia, it's also in Dominican Republic. There are common weaknesses. Because if I tell you that the insolvency process is costly, is lengthy, is complex, it sounds that I am referring to the insolvency process in India, right? But that's not only an Indian problem. That's a problem existing in most countries around the world. If I tell you that companies don't have access to new financing, you may think that I am speaking about the Indian insolvency system. But it's not only about India, it's about other jurisdictions. Or the lack of certain tools that can facilitate a value-enhancing restructuring, such as a cross-class clampdown, which is the possibility of imposing the plan on dissenting classes of creditors, assuming that the plan is going to make everyone better off. Sometimes we require the mandatory appointment of an IP, an insolvency practitioner, because we saw that that was a good practice, according to the international organizations, or we saw that this is what Singapore or the UK may do for administration and judicial management, and we replicate those laws, and we require, of course, the appointment of an IP. But unfortunately, many emerging economies don't have the luck to having the fantastic pool of insolvency practitioners that India may have. Many emerging economies don't have sophisticated insolvency practitioners. They don't add the credibility and expertise that is often needed. So that's why sometimes the appointment of the IP may end up doing more harm than good for the creditors. Because of course, they will charge their fees, and the remuneration of IPs will reduce the pie available for the creditors. And of course, if you add value, that is totally justified. But unfortunately, in many emerging economies, IPs don't have that sophistication, that credibility, that independence to add value. And also sometimes corporate directors are subject to a very tough liability regime in many emerging economies around the world. In the United Arab Emirates, until very recently, the directors could end up in jail. Even if the company was solvent for, honest, but, unfortunate kind of reasons, still the directors were facing this tough liability regime. So the system doesn't look very appealing, right, to debtors. Some of you might say, well, but that's probably because these countries have more creditor-friendly systems. Well, unfortunately, that's not the case either. So in most of the countries, and I've been analyzing about 80 jurisdictions around the world, and I've seen in many countries that the system is not attractive to creditors either. India is an exception. Maybe in India can meet some of the features that I mentioned for the unattractive insolvency process for debtors, but when it comes to creditors, it's relatively far more attractive. But still, we find exceptions in both scenarios. So for example, in Colombia, in Latin America, debtors have access to the deep financing regime existing in the US and Singapore. Whether that is a good or a bad idea, that's another thing. So far, I am just analyzing the law on the books, but the law on the books provides certain deep financing provisions that replicate the deep financing provisions existing in the US and Singapore. In China, debtors have a cross-class crackdown, which is also this possibility of imposing the plan on dissenting classes of creditors. So that's why there are some exceptions. So some countries have relatively attractive, good laws on the books for debtors. But then when we look at the attractiveness for creditors, we can see that, again, the process is very costly, very lengthy. Creditors don't get paid. I saw some statistics in Australia showing that unsecured creditors get, on average, nothing in many administration cases. So that's why the procedure is not attractive to them. It's more attractive to secure creditors in Australia, for example. But for unsecured creditors, it's not attractive. In many countries around the world, the best interest of creditor test doesn't exist, meaning that you can approve a reorganization plan, and if the creditors get 30%, if they show that they would be better off in liquidation, maybe they can get 50%, which is more than the 30% that they're getting in the plan. In the United States, for example, this plan cannot be confirmed. Well, unfortunately, this rule, this best interest of creditor test, or this no worse off rule, doesn't exist in many jurisdictions around the world. And you might be required to accept a plan even if you would be better off in liquidation. So that's another weakness of the insolvency law on the books, making the process less attractive to creditors. So again, there are many exceptions around the world, but the general perception that they got after analyzing all of these laws and all of these variables is that in general, insolvency law is relatively unattractive, even on the books for both debtors and creditors. But then let's look at the institutional environment, because things can get even worse. I read a few weeks ago the statistics of the Insolvency and Bankruptcy Board of India that I've included in my book. And I found very surprising that in 2022, the average period to decide whether a case should be admitted or not when it is initiated by operational creditors was, if I'm not wrong, 150 days. So almost 2 years to decide whether the case should be admitted or not if it is initiated by operational creditors. Almost 2 years. So of course, India is very lucky to have very competent judges, an independent judiciary, but of course if these judges don't have the resources, then of course they cannot decide quickly. And then the law says that they should decide within 14 days. So of course the institutional environment has something to do with it. But what my book says is that the problem is not only or necessarily the institutional environment, it's also the law. Because the law has been designed taking into account an institutional environment that doesn't exist in India. So that's why we need to reconsider that. We need to reinvent insolvency law in emerging economies because it's not designed to deal with the market and institutional reality existing in emerging economies. Then when we look at the market, we cannot find an active market for distressed debt, for distressed assets, litigation, funding, deep financing. So all of these factors that we can find in some of sophisticated insolvency systems like the US, like the UK, like Singapore, this is also missing in most emerging economies. That's why it's not surprising that when we look at the statistics and we look at the number of insolvency proceedings in emerging economy, do you guys know what is the average number of reorganization procedures a year in Ecuador, in Latin America? 1.5 is the average number of reorganization procedure a year. One procedure a year. Mexico or Thailand, about 40 procedures a year on average. Ghana, I'm not aware of any insolvency procedure since the law was adopted in 2020. Nigeria, something similar. Myanmar, something similar, even though Myanmar has a relatively sophisticated law on the books. It was adopted in 2020 and is relatively sophisticated. So India or China also have very low levels of insolvency proceedings when we compare the data in India or China with the size of the economy and with the number of insolvency proceedings existing, for example, in the United States. Some people would say, well, debtors don't want to use the procedure because the stigma exists everywhere. I mean, in the US, you don't wake up in the morning and say, oh, I feel like filing for bankruptcy. So this is such a rewarding experience. No. You file for bankruptcy because the system will help you. By filing, you can automatically get the protection of the system, the moratorium. And then once you are in a system, you can get financing. There is a fantastic paper wrote by Professors Ken Ayotte and David Skill. It's called Bankruptcy Law as a Liquidity Provider. And what they say is that insolvency law in the US serves as a liquidity provider. Not because by filing for bankruptcy you will get money from the government, no. It's because by filing for bankruptcy, then you have certain provisions that will facilitate that new financing, will encourage lenders to extend credit that wouldn't extend otherwise outside of bankruptcy. So that's why by filing for bankruptcy, you're going to be better off. But unfortunately, that doesn't happen in most countries around the world. So that's why debtors and creditors are rationally reluctant to insolvency proceedings in most emerging economies. But they are rationally reluctant. It's normal with such an attractive insolvency environment to be reluctant. And reluctant means the three things that I told you at the beginning. Don't start a business, don't borrow, don't take risks, which is going to be harmful for the real economy. And also reluctancy means that once you face financial trouble, you don't have incentives to initiate the procedure in a timely manner. So you want to avoid that at all costs because the process is not going to help you. So of course, if that happens, then you may end up having some of the problems that India, based on what I've seen and I've heard, is having, which is that companies file for bankruptcy too late once many viable firms can no longer be reorganized, or once they need to be reorganized with huge haircuts that can be very detrimental for the creditors. Well, but the problem is that, first of all, they have initiated the process maybe too late. But maybe it's because, first of all, the law itself requires to initiate the process a bit late because it requires default in the first place. It requires insolvency. Unless you are already in trouble, you cannot even initiate the process. So the law itself is not even facilitating the quick recovery of the company. And secondly, if it takes several months to initiate the process, probably you will ultimately end up initiating the process when it is too late to reorganize the company or to maximize the recoveries for creditors. So that's why the system is not appealing at all. And that explains in part why we don't observe many insolvency proceedings in many emerging economies, or why the procedures are initiated once it is too late to achieve the goals of insolvency law that I mentioned at the beginning. So that's why insolvency law fails to perform the functions that it's supposed to perform in the real economy. Not only ex post, but the important functions that I mentioned ex ante. So it's not helping us reduce poverty and create growth. It's been useless in many situations or in many countries because it's not really helping us. So that's why we need to make insolvency law a more powerful tool to reduce poverty and create growth. And the problem, at least in my view, is that the law has been designed taking into account a market and institutional environment that is not realistic. It is not a market and institutional environment existing in emerging economies. So that's why the law needs to be reinvented in insolvency in emerging economies. And reinvented how? Well, what I say in the book is if the judicial system doesn't work, and by the way, it doesn't work, when I analyze, I have one whole chapter for the institutional environment, I analyze the weaknesses of the judicial system, and I distinguish several features of the judiciary. You may have a judiciary that is independent. The ideal judiciary should be independent, should be efficient, should have the resources, should have the expertise, predictability, attachment to the rule of law. That's the ideal scenario, which is the scenario that some countries like Singapore, somehow the US, particularly some courts even more than others in the United States, the UK, and a few other jurisdictions. But if you don't meet all of these requirements, and by the way, this is something that many advanced economies don't do either. In many European countries, for example, they are advanced economies, they have independent judges, they have judges maybe with the resources, they have even, if we think about Germany, for example, an efficient judicial system, but the judges there don't have the expertise, for example, to handle complex financial and commercial cases that judges in Singapore, the US, or India, or the UK may have. Why is that? Because it's the system for the appointment of judges. In Spain, for example, I read a few weeks ago that a person became a judge at the age of 24. 24, you can become a judge. Why? Because what you need is a law degree and then to pass a public exam. A tough exam, by the way. It's a tough exam. But if you pass that exam, you can become a judge without any professional experience, without the need to have seen a single contract in your life, and you become a judge. So of course, with those features, you may have an independent judiciary, efficient judiciary, but you don't have the sophistication needed to handle complex insolvency cases. So that's why my book actually ended up with a chapter saying, Reinventing Insolvency Law in Emerging Economies and Beyond. And by beyond, I put together many of the advanced economies that also need to reconsider their insolvency laws precisely because of the market and institutional environment. So that's why if the judicial system doesn't work efficiently and effectively in a credible manner, we need to minimize the use of the judicial system. That's what I said in the book, and I can explain how. Then, if the public sector, again, faces problems of corruption or lack of efficiency, then we cannot rely on public authorities to be actively involved also in many insolvency proceedings. So in some countries like Colombia, for example, public authorities can initiate an insolvency procedure. So it can be initiated not only by debtors and creditors, but also by the superintendents of companies. Even if it's not a financial institution. I'm not speaking about the special institution like insurance company or banks. No, regular companies, and you have the public sector. In most countries around the world, the public sector also enjoys a preferential treatment in the ranking of claims. But if we have problems of corruption, for example, and the public sector is not going to efficiently use the resources collected from taxpayers, maybe it would be much better to abolish that preferential treatment in the ranking of claims that many public authorities have, and then the recoveries for unsecured creditors will increase, and there will be more money in the private sector that can be used to pursue value-creating activities. If the system is mainly formed by micro and small enterprises, of course we need an insolvency procedure that will work for them. Some countries, India is one of them, or Australia, Singapore, have adopted some simplified insolvency frameworks, but some countries have failed to respond to the reality of the country. India has adopted this pre-pack for micro and small enterprises. But first of all, it's not for small enterprises, it's for small companies. So if you are a sole trader, as far as I know, you don't have access to that procedure. So you will need to use the rules for personal insolvency. But actually, as I mentioned earlier, looking at the statistics, more than 90% of the micro and small enterprises in India are sole traders. So that's why the law is excluding the majority of micro and small enterprises. So if we have also inefficient insolvency proceedings, even if we, of course, amend some of these recommendations that I'm going to mention in a minute and I develop in the book, then if the insolvency proceeding is, as it unfortunately is in many countries, value destructive, so it destroys value for both debtors and creditors, maybe we need to avoid the use of those inefficient insolvency proceedings by actively promoting workouts. We heard yesterday that India is in that direction, promoting hybrid procedures, but not forcing companies to use a procedure that is going to make everyone worse off. So that's why we need to think about insolvency law differently. And I'm going to mention some of the ideas that I discuss in the book, so in different chapters of the book, about what the emerging economies should, at least in my view, do. When it comes to the insolvency proceeding itself, the formal insolvency process, that needs to be redesigned. Redesigned taking into account the reality of emerging economies. As I mentioned, we need to reduce the involvement of the judiciary. Because, again, lack of expertise or lack of efficiency or lack of resources or lack of independence, unfortunately, in some emerging economies, all of these problems together, in some countries, maybe only some of them. But if we have this problem, we need to reduce the involvement of the judiciary. How? Well, for example, when it comes to the initiation of the insolvency process, then if it takes almost 2 years to initiate an insolvency proceeding, then, and to get the protection of insolvency law, maybe we can adopt something similar to what the US has, which is the automatic stay. And by filing for bankruptcy, you automatically get the protection of the moratorium. And some of you would say, well, but that can lead to opportunistic behavior by the debtor, right? And we don't want that, because that is the case where lenders, again, are going to be reluctant about the possibility of extending credit, and that may end up harming the economy. And I totally agree. That's why what I said is that we provide the moratorium, but at the same time, we allow the creditors, or at least a percentage of the creditors, to terminate the procedure or to terminate the moratorium at any time without court review. The creditors themselves, 25%, the majority, up to each country to decide, but the debtor will initiate automatically, but if the creditors want, 1 year later, one day later, or 1 week later, they can terminate the process. When it comes to deep financing, again, Colombia has adopted this regime from the US, apparently saying, well, we are going to adopt all of these sophisticated provisions. Yes, but the US is a country with a very efficient, or Singapore, very efficient, sophisticated judiciary, and deciding whether the new financing should be approved or not is a very complex decision. I mean, I've never been a judge, so we can ask some of the judges, but I've always believed that these are really complex decisions, because you need to decide whether the new financing is going to make everyone worse off or better off, and to authorize the new financing only if you think that everybody's going to be worse off. Sorry, it's going to be better off. So, meaning that your decision will involve valuation issues, will involve projections, will involve assessing the investment that the debtor is planning, assessing the viability of the debtor itself, assessing the impact of that on creditors. And not only that, if you make a bad decision, and by bad decision I mean ultimately authorizing something that is not going to create value or preserve value, and therefore it makes ultimately the creditors worse off, your decision, it is in your shoulder that is going to be making the creditors worse off, and that's why lenders in the country will have incentives to increase the cost of debt, and that may end up harming the economy. So it's a very complex decision. So that's why I don't think the judges in most emerging economies have the resources, sometimes the expertise, sometimes the efficiency of the judicial system to make this type of decision. So that's why this is something that should be done by the creditors. And some of you may say, well, that's what we have in India. The Committee of Creditors should be approving this. So that's why many emerging economies have something to learn, many things to learn from India, and this is actually one of them. And I totally agree. But I don't think the Indian system is perfect either, because the decision is made, if I'm not wrong, by the Committee of Creditors, meaning the financial creditors, meaning that many secured creditors are going to be deciding this authorization of new financing. And secured creditors, if they are over-secure or fully secure, they don't have incentive. Do I need to finish? Sorry? Oh, do I need to finish? Or? Okay, so do I have, okay. Okay, so just to conclude. So, because I was getting excited, as you guys can see, I'm very passionate about this issue. So it's even better. I mean, my publisher, Cambridge University Press, is going to be very happy that I'm not disclosing everything. So you guys still have incentives to buy the book. The point is, the book discusses how exactly we need to be reinventing insolvency law in emerging economies, how we can actively promote workouts, because many countries say, yeah, we need to promote workouts, and then they do nothing to promote workouts. So they impose liability for insolvent trading. And that's why directors don't even have incentives to actively try to reach an agreement out of court. Directors' duties: if we have an inefficient insolvency system, we cannot impose a duty to file for bankruptcy, as Cambodia, Vietnam, United Arab Emirates, or many European countries do. So that's why, and also, if the system itself is not efficient even after amending the system, why not allowing debtors to choose an insolvency forum? So if you are a debtor from Bolivia with a very unattractive insolvency system, why not allowing that debtor from Bolivia to choose in the company's constitution, for example, that in the event of insolvency, they will go to the US or will go to Singapore? If you do something like that, debtors in Bolivia will have more access to finance. So if the system is not helping the economy in Bolivia, at least this freedom of choice will allow debtors to obtain more financing, to promote more entrepreneurship, to promote more growth. And of course, some of you may say, well, but that can lead to opportunistic behavior if you choose the insolvency forum, because sophisticated lenders, of course, they will price that. But what happened with employees? What happened with third claimants? Well, what we need to do is to provide a preferential treatment to all of these non-adjusting creditors, regardless of the jurisdiction that you choose. But if you do that, instead of choosing the COMI, the center of main interest, yesterday, Mr. Suman Batra mentioned that I was kind of laughing when he was saying that UNCITRAL has been saying some proposals and encouraging countries to adopt some rules. And I fully agree with some of those proposals. And the first one is the key aspect of the model loan cross-border insolvency, which is the center of main interest. Because if you have your assets, your office, your everything in Bolivia, then that means that you are kind of required to initiate the insolvency proceeding in Bolivia, and that you are required to bear all the significant costs and inefficiencies existing in the Bolivian insolvency framework. So it's going to make the whole country worse off. Of course, you can still file for bankruptcy in the US or Singapore if you show the connection, but still you may have problem when it comes to the recognition of the procedure if you initiate the procedure in a place that is not your center of main interest. So why not favoring the choice of insolvency forum ex ante at the very beginning, so companies may have more access to finance? So I think there is a lot of work ahead. I think we all need to reconsider the way we design insolvency laws in emerging economies. And that's why, again, I would like to congratulate you all, particularly the organizers, Institute Management Bangalore, Insolvency and Bankruptcy Board of India, because we need more events like this one to try to think together with how we can all improve our insolvency systems, because sometimes our politicians, our regulators are not aware of the importance of insolvency law, because insolvency law is indeed a powerful, or could be a powerful mechanism to reduce poverty and to promote growth. Thank you so much, and my apologies for that.
Good afternoon to all of you. I think being the last speaker in the entire forum, I am going to say, I think you would have heard it in the last 3 days, all the things. But what here I am going to touch upon is from a banker's perspective. As a banker, what is the relevance of the IBC law? And before commencing, I want to thank Dr. Jaydev sir and CCM RM Vertical of IIM Bangalore for allowing us to be a Union Bank of India to associate with these discussions. And I once again thank you for that opportunity, sir. As a banker for more than 30 years, I will say that IBC is one of the best resolution firm which is available to the banker. Though many may say that there are so much delays, there is admission is getting delayed, but give an opportunity to the IBC. Whatever we are presently doing, all have been a NPA in a long time back, which we are getting it now. even if you look at it, 30%, normally now the industry trend is around 30% you recover in your book value or your running ledger. You are recovering 30% of that is what against IBC they are saying. But look at the recovery against the liquidation value, because that is the value of the asset at the current market rate. If you are looking at it, it is more than 150%. So it is not fair on our part simply to put it that saying that IBC is not effective and it is not doing the way it is. No, it is not like that, because whatever resolution has happened, these are all been a long time non-performing assets, and which we are able to do it. Still, as a banker, practical banker, I can say that IBC gives us, the bankers, a confidence to talk to the client, saying that that this will be one of the mechanism, and it also gives the confidence to the banker, saying to take the commercial decision, say that to even change the management, because it is a very, very, very clear over-the-counter process, which helps the banker also to justify the decisions, commercial decisions. In the panel discussion, I saw one question comes that how you are approving resolution plan below the liquidation value. Please, that now only we have started, after we are being questioned by for every action that we are taking it. Now only we have started because we have the belief in the judiciary, which is supporting us in the IBC. Again, these type of things, again, will put back the decision-making authority and the commercial decision which bankers are supposed to take it. It is at that time correctly told that if today I am getting it in the resolution plan, liquidation value is only an estimate. I may not get it tomorrow. We have experience. So it is not with numbers we have to look at the decisions. Certainly, I expect that this will be taken, and this is going forward, this will be one of the very good tool for the bank. Yes, IBC, basic principles are maximization of value. But as a banker, what we look at IBC is, one of the very, very important is availability of credit during the process. Even if the account already it is in a non-performing or in a station, it allows further credit and also to run the account so that the value maximization happens on that. Number two is the moratorium which is being allowed to us. We have seen many cases in the past where few bankers were deciding to go for a resolution of an asset. Even now also it happens. But suddenly one of the lender chooses to go to DRT or file. The entire resolution process gets stalled because of that. But IBC, it allows a moratorium period where we can work out. And if that, and it gives a very, very comfort to the bankers to take the decisions, even for change of management. And yes, there is a delay because of there are a lot of extensions were there. But if you look at the back, if you are seeing the average, from our bank, I could say that the average resolutions which are happening, or yearly recovery happening, was around 4.3 years. Now, because of IBC, it has come to 1.6 years. It is now only it's been there, and we have to allow this to season itself so that the best benefit of IBC can be got for the both economy. As rightly told by Martinez, it is good for the economy that the asset should not be allowed to depreciate. Bankers, as a banker, I can say that we always, to the last mile, we will see that how to save the asset. We don't want to sell the plant in a scrap value at any cost, because that is having an employment opportunity for the economy, and that gives a lot of comfort to the bankers. So that the other very, very important is it also allows a default, a one-day default also. It allows for you to take the NCLT route. You need not wait for the account to become 90 days, after 90 days. Even during the comforts, what it is giving. Yes, there are some disputes or some frictions are happening between the IP and the COCs because it is a working process. Once both of us, we know that we have to coexist, it all will even out, and I expect that this law has to be updated itself on a regular basis to make it as a powerful tool for, not for recovery, but for resolution of the assets. Thank you once again. I thank Mr. Jaydev sir and also CCMRM of IIM Bangalore for giving us the opportunity. Thank you very much.
Thank you, sir. Now I would like to invite Professor Jaydev to honor the guests and present them a memento as a gesture of thanks. Thank you so much, sir. It's really momentous. It's an honor to have you in person with us, sir. Thank you, Shri Subramaniam, sir. Thank you, sir. So now the time has come to announce Best Paper Award. And I would like to invite Professor Jindal to say a few words on how they arrived at the criteria for selecting the Best Paper Award. Please make way for Professor.
So first of all, thank you, Professor Jaydev, for giving me an opportunity to be a part of the committee for selecting the Best Paper Awards. Now, I must confess on behalf of the committee that it was certainly not an easy task to choose 2 best papers from a pool of 40 high-quality papers that were presented at the conference. So the committee chose a number of criteria to arrive at the Best Paper Awards. So we looked at, first, the incremental contribution of the paper. So here we looked at what is the research question that the paper addresses and what is the contribution of the paper to the prior literature. The second is the relevant literature, whether the paper has taken into account the relevant literature in the field. The third is the methodology. So whether the methodology employed by the paper is suitable to address the research question that the paper intended to examine. And finally, we have looked at how well written the paper is. So based on these 4 criteria of incremental contribution, relevant literature, methodology, and writing, we have arrived at 2 best papers. So I think Professor Jaydev is going to put an end to the much awaited event which many of you have been waiting for. So over to Professor Jaydev.
So I would like to inform that the Best Paper Award is sponsored by Union Bank of India, and the winners will get 10,000 rupees as cash prize along with an award. So now I will announce the Best Paper Awards. And as Professor Jindal has mentioned that it was so tough, they couldn't come with 1 award, so there are 2 winners. So first paper to win the Best Paper Award is, do firms have a preference while repaying lenders? Relationship versus transactions banking by Mr. Nitin. Can we have Mr. Nitin? Thank you, sir. Congratulations. Can I invite Justice Kannan to please do the honors? Honorable Justice, can you please award the memento to the winner? Thank you, sir. Congratulations. Now I will announce the second winner. So the next winner is from the home buyers conundrum in real estate insolvency. So I would like to invite Ms. Mehreen Garg, who is the co-author, and the other author, Professor Arja, couldn't be here. So congratulations, ma'am, for winning the award. I would like Professor Aurelio to please do the honors and award her the Best Paper Award. Congratulations, ma'am. very hearty congratulations to both the winners. They have really done a very good job. So now, with this, I would like to invite Mr. Sudhakar Shukla, whole-time member IBBI, to please conclude the conference with few remarks. Please.
Honorable Justice Kanan, IBA CEO, Mr. Mehta Saab, Joint Secretary, MCA, and many more. Suraj Bhan is there, and we have a stream of dignitaries, so naming everybody would be difficult. But definitely, all the participants coming from abroad, I think we have to thank them first to make it, because their contribution made it a truly international conference. So a big round of applause for all the participants who have gathered here. As in, if you have read Gita, so opening line is basically, it's a narration coming from Sanjay addressed to Dhrishrat. So Dhrishrat is not in the field, but he is trying to get all the feedback from Sanjay. So as a Dhritarashtra, I can say my people were around all the time to gather the information and relay it to me. But somehow Sanjay has fallen ill, so that paper has not come. So I have to grope in the dark, but surely I have been part of many of the deliberations, so I would be trying to sum up. Actually, I have to begin with our sense of gratitude to IMB for being a perfect host. And if all of you recognize it, so please don't hesitate. I think Professor Jaidev ji and Vrati, Aishwarya, and also I think Dr. Abhinav contributed a lot towards success of this conference. If they are around, they can stand up and wave to the crowd. So in departure to last year's conference, we had a strong presence from Ministry of Corporate Affairs as well. I thank Madam for her gracious presence and participation, and also other dignitaries coming from MCA who made it possible to be delivering a kind of outputs which we were intending, and the intention behind, and the first inaugural, if you recall, it is basically you are focusing on outcomes. So outcomes, what will come finally in the safe hand of Madam. So I think a round of applause for MCA for being here and taking down all the pain and in noting down what is emerging from the conference. Briefly, I want to say that this journey of this, we say it's a data-based, data-driven decision-making. So this started 2-3 years back, and this was conceptualized during the COVID, because at that time actions were low, and we all thought it is a time to pause and ponder, to give data a push through online methods, so that we are focusing on being relevant in the sphere of insolvency. So that's how it all started, and we formed a research guidance group under Dr. K.P. Krishnan, and Dr. K.P. Krishnan could not make it, but I think from their first conference was decided, Professor P. Ram Mohan is here, who hosted the first conference in Ahmedabad. Can you please stand up, sir? So we are just recognized in recognition. So it was such a grand success that basically we cannot forget the hospitality you extended to us. Thank you very much. And the kind of hospitality we are getting is also, I think we are carrying forward that kind of culture. And each of us actually who was placed outside this campus was trying to come in and be accommodated here. At least I was trying. So I was told that this campus has place for only 3 idiots. So fourth one cannot come. So I was forced to be out. But I thought whatever feedback we have got is a very positive feedback on kind of hospitality you have, the stay, comfortable stay, and lavish food is, of course, is the order. Then we come to basically the crux of this conference, how it is international. Basically, last year, we got the presence of UK, USA, and Mauritius, 3 countries. But this time, we have 7 countries participating in various forms. So it's a big achievement, and I thought good contribution coming from Jaydev Saab and also Badra Saab, who managed such a extreme faculty from abroad. And if I name the countries and the names, I think Singapore, we have Justice Khan, and he's sitting till last, gives us the encouragement that we are doing right. So thank you, sir, for being here. And we also have Mr. Martinez, and for such an excellent paper, for valedictory paper, so many insights. There's differentiated approach to insolvency is not new in debate. If you go by Booth hypothesis, it says grain of the soil is very important. You also have some researchers calling it that these best practices, we loosely say, are actually should be context specific. So what he is explaining is basically grain of the soil is important, and best practices emerging from the country are important. So those things I thought a good takeaway from his valedictory address. But if you link it with the first lecture in the series, Professor Wig, such an excellent exposure, basically he is also saying similar thing with different explanation. He said that harmonization is inevitable in terms of what we are seeing in international developments and globalization. So that standardization you cannot avoid. But flip side is that basically if you rely too much on that, you are sacrificing the local content and local expertise and local innovation. So I thought those points relate very well what he said at the end. So beginning and the end, the theme is underlying that we have to learn from outside, but we have to be vigilant about the context and how to deliver what is required to be delivered in Indian context, Indian realities, and to take this regime forward. I thought then we have 2 or 3 participants from US, Professor Wig I already mentioned, then Mr. H.M. Spragan, and also I'm not counting her as a US representative, but World Bank representative, Ms. Antonio Maniz, who also participated in various deliberations. I think participant from Japan, Hiroshima Kosua is again is here. So kindly. So we also had some insights from Hong Kong. So madam, can you? And also online we were joined by Shri Ajit Niwad Cabral from Sri Lanka. So this is the list, but we could not wish away to say that UK also participated through, like, not only as a sponsor, but their deputy commissioner was present here to inaugurate the conference. So it is very much what we see in the menu. And now coming to some basically themes which we have discussed actually. Many of you may not be knowing, but we started this conference with a inauguration of EV stand there where you can charge your electrical vehicle as a part of recognition towards environmental issues. It started with the opening of that. Then if you see what the organizers have done, basically this identity card does not have the plastic cover. You don't have convenience of plastic bottled water. So round of applause for environmental friendly techniques which you are at display. And that discouraged me, actually encouraged me to ask in the last session that why not, when Mother Earth is taking the haircut, then why not to have some discourse on like how insolvency regimes can shift the brownfield projects into green technology. So that discourse, I think, some research from IIM would be needing, but I think international community is agile. We will be also happy to partner this thought. And in moving forward, perhaps some 5 years down the lane, this would be a necessity. So otherwise, all of us would be unemployed because changes are taking very fast and environment changes are really alarming. So then in the themes actually, we also discussed about SMEs. SMEs recipes were very clear what they want. We discussed one side of the story only. These are the, basically SMEs we are talking who are undergoing insolvency. But SMEs as a claimant under the waterfall was an issue which was side-parked, basically sidelined, or maybe the experts were not very forward in saying that how to provide some solace to the SMEs in the waterfall mechanism. The third one was basically today we heard the stakeholders conference chaired by our WTM Jayanti ji. And whenever it comes to like what is his stakeholders' input on insolvency regime, one idea comes into mind is it is an elephant in the dark room. And who is evaluating is some blind person. So what is happening is whosoever touches the head says about haircut. There is no hair. Whosoever touches the tail says recovery is very less. No recovery. And whoever touches the feet says that there is a procedural drag. Like valuer is saying it is not an elephant at all, it's a donkey we are dealing with. So basically when resolution applicant comes, he visualizes the elephant, its size is big, let us work on it, something will come surely. So all perspective are coming in that way in the room. In reality, it may be different, but we are all working towards value maximization. I think I will be failing in my duty if I don't acknowledge the hard work done by IBBI team also. I think Ritesh ji led the team here. And Pooja was there coordinating with him. All the girls were busy on the software part of it, all the typing, all the outputs which you are seeing in a time-bound manner. This was all contribution of the managers, lady managers from IBBI. And the boys, however, were busy in the hard tasks. No, I'm not saying hard drinks. So basically, they were busy with logistics and other comforts to ensure that basically that your comfort was very promising, or maybe when we plan a third conference like this, then it could fructify more. So, and the crux was basically the 40 papers which we have uploaded, to winners we have uploaded, but we have to applaud for all the 78 papers which were submitted to us, and we could not graduate them due to the time constraint. I never say they are qualitatively weak, but there was a rigorous selection process led by Dr. Jaydev Saab. So even our papers like submitted by IBBI, because when they were evaluated, names were removed. So most of papers submitted by IBBI were rejected. So that gives again like you can see the credibility of the process. Ajanta could survive, but Pooja could not. So but this was an impartial, I thought, takeaway that basically it was very fair what we did in getting those papers. Now we have asked for consent to publish them in a book. Last year we published. We have got some book consents already. Others we are again requesting through email, you give the confirmation so that we can publish. And we also try, we will try that out of the 178 leftovers, we will work with them so that we can bring out more papers in the series in coming months. With this, I thank you all for being here with us. Thank you very much.
Thank you, sir. Thank you.
No, that is why I'm saying, I said in the beginning I lost my paper, but I have a big thanks to all the sponsors and British High Commissioner. And your rounds of applause should go to the sponsors as well. British High Commissioner, NESL, Union Bank of India, Bank of Maharashtra, SIDBI, and above all, ILA for sponsoring so many resource persons to be with us. Thank you very much.
Thank you, sir. I would like to invite Professor Jaydev to thank him. Sir, please wait. We will like to award and present a memento as a token of gesture of thanks. Sir, please.
Yeah, already Shuklaji has covered very extensively on behalf of IIM Bangalore. First of all, thanks to IBBI for giving this opportunity, and it's no doubt it's a big work and it's a deviation from the regular work also, but it is mainstreamed with the research which is going on. A couple of PhD students are working already and some are highly motivated to work. So I'm sure this is converge with the research activity at the IIM Bangalore and will move forward. And many of my colleagues who are here, actually referee process, he put everything on me, but I am not the person. We have various teams we have constituted for review process, and it was unanimous review has been done. My faculty colleagues, Varun Jindal, Devjit, Venkatesh Panchabageshan, and Sabarinathan, and Padmini, so many people, all of them have done this work, Abhinav Anand, and thanks to them also we have constituted the committee for evaluation of the best paper, and Professor Varun Jindal and Anirudh as well as Devjit was there, and they have Padma and Prabhu Venkatachalam there. Just they submitted their PhDs and waiting for the award. They are also included because they know best what is happening in the market. So they know how to evaluate it. So this is how the process has taken up. And I'm very much thankful to entire administrative team. I think first Vice President is coming. They have come to see the protocol issues and all that one. I am seeing that our team people moving around here. So thanks to all of them and our logistics team. They have helped a lot, especially our caterers. And I'm sure you are all happy with the food being served for the last 2 days. Hope you are all healthy and energetic to go back to home, right? Wish you all the best. And thank you very much if I am missing anybody. And above all, for the last 2 months, my team members, Dr. Aishwarya Krishna, she and Vritti, extensive work they have done apart from the IBBI, along with the IBBI team. Continuous phone calls, so many emails, and sometimes Zoom calls and meetings. These things has been successfully concluded. Thanks to many dignitaries who have come all the way, and Sri Suman Batra, Sri Ramesh Kannan, and City Hong Kong professor, and of course, when I just said, you please can you come from all the way Japan, he has a lot of visa problems. But all that he has taken time to solve all those things on his own, and have taken the interest to come, and Vikrant Vihang, because coming 18 to 20 hours journey and coming here for the sake of one lecture is really, he has interacted with our PhD students also very, very motivating. And I'm sure these relationships will go long and will have a fruitful work in the future also. Thank you very much. So lunch is arranged for all of you. Please join for lunch and let us meet some other time. Yeah.
Sir, please, we'll award a memento to Shri Sudhakar Shukla as a gesture of thanks, heartfelt thanks for giving us this opportunity, sir. Thank you so much. I would also like to invite Mr. Ritesh Kavadia, and we would like to present him a memento as a thanks for all his efforts. Thank you so much, sir. We really appreciate and value. Ritesh. Thank you, everyone, for your patience. With this, Miss Pooja Singla, please join.